5 seconds to go. Start. It is therefore imperative that the fundamental right of a pregnant person is not compromised for reasons other than to protect the physical and mental health of the pregnant person. The opinion of the RMP or the medical board, as the case may be, is indispensable under the scheme or the MTP Act. This inadvertently gives the power to the RMP or the medical board to stand in the way of a pregnant person exercising their choice to terminate the pregnancy. When there is fear or apprehension in the mind of the RMP or the medical board, it directly jeopardizes the fundamental freedoms of pregnant persons guaranteed under the Constitution. Therefore, this court has in the past opined on the pattern of conduct in medical boards and sought to align it with legal and constitutional guarantees so as not to render the fundamental rights of persons before these boards nugatory. In Bambaniya Sagar Vashram Bhai versus Union of India, this court has held that disability assessment boards must not adopt the approach of a recluse by confining themselves to only quantifying the disability of a candidate. In that case, the medical board had reported an unreasoned opinion that the candidate was ineligible to continue his MBBS course on account of being more than 80% disabled. Like in A, Mother of X Supra, the court in Bambaniya Supra also emphasized the need for elaborate reasons by the medical board while reporting their opinions. In Purshawani Ashutosh versus Union of India, this court was deciding if a medical aspirant who had appeared for the NEET UG exam 2018 was eligible for the reservation earmarked for persons with disabilities. Despite having low vision impairment, the medical board had opined that the petitioner in that case was ineligible for reservation. While rejecting the opinion of the committee, this court held that a medical board cannot be allowed to override the statutory mandate of providing reservation to persons with disabilities. No committee has primacy over the law. We must emphasize that the opinions of medical boards and committees are not only required to adhere to legal standards but must also embody core principles of the rule of law within their processes. This court, following a consistent line of precedent, has underscored the need for reasoned and transparent decisions by such boards given the profound impact these opinions have on the life trajectory of individuals before them. At its core, the rule of law demands predictable rules, equitable application, unbiased adjudication, and fair, transparent treatment of individuals. In cases of assessment, this entails informing individuals about the procedures, standards, tools, and all pertinent aspects of the assessment in advance. Such transparency is essential to avoid any arbitrary uncertainty arising from obscure or inconsistent procedures. The procedures must be inherently fair and bear a rational and cogent nexus with the purpose which is sought to be achieved. A committee's role goes beyond mere quantification of disability. Disability is a factual condition. The key question for a disability assessment board is whether an individual with a disability, aided by modern scientific tools and devices, can enter the MBBS program. Put differently, the board must assess whether it is infeasible for the candidate to pursue a medical career with their disability. Appendix H1 stipulates that assessments, particularly for individuals with locomotor disabilities exceeding 80%, should focus on evaluating functional competence. This functional competency test serves two critical purposes. First, it emphasizes the abilities of the person with a disability assessing their capability rather than their limitations. Second, it mandates an evaluation rooted in practical relevance, aligning the candidate's abilities with the functional requirements of the MBBS curriculum. Mere quantification of disability is insufficient and fails to address the necessary criteria, a position this court has consistently upheld as unsatisfactory in such cases. At this point, it is imperative to deal with the holding of this court in Vidhi Himmat Kataria versus Union of India. In that case, persons with disabilities who had appeared for the NEET UG exam 2019 had moved this court against their disqualification by the medical board. Appendix H had been issued midway through the process for admitting candidates from the NEET UG 2019. The primary contention of the petitioners was that since the new guidelines were issued in the middle of the admission process, they must not apply to the ongoing process. The petitioners prayed to be tested against the rules as they existed at the time of the application process for the examination, namely the MCI guidelines of 2017. On this count, the court ruled against the petitioners. The temporary argument of the petitioners was that they have not been tested on relevant parameters. This court, while rejecting the argument, noted that the petitioners were disqualified for not meeting the eligibility criteria of having both hands intact with intact sensation, sufficient strength, and range of motion. Accordingly, the court refused to sit in appeal over the expert body's opinion. The judgment of the court in Vidhi Himmat Kataria Supra was specific to the facts of that case and did not involve any question of interpretation or constitutional analysis. The court was not examining any criteria and did not scrutinize the guidelines to inspect their validity. The court did not have the benefit of looking at the firm roots which reasonable accommodation has grown within the fold of the Constitution. Further, the judgments of this court in Vikas Kumar Supra, Avani Prakash Supra, Ravinder Dhariwal Supra, and Omkar Gond Supra were not available to the court while dealing with the case of Vidhi Himmat Kataria Supra. Therefore, the opinion in Vidhi Himmat Kataria Supra is inapplicable. Courts are not expert bodies in matters of medicine. The competent authority to adjudge the eligibility of a person to pursue a medical course is the Disability Assessment Board. However, courts have the jurisdiction to ensure that the manner in which the board proceeds and functions is in compliance with established principles of law. Ultimately, the court will have to rely on the opinion of the board to adjudicate the legal remedies of a person with disability. The interference of courts is not to supplant its opinion for that of the experts but to ensure that a holistic evaluation of competence is conducted and that no person's career is set at naught with the stroke of a pen. The courts cannot be stupefied into inaction by the lack of adequate framework or expertise when questions of fundamental rights emerge. No person forfeits their claim to education or other pursuits of life on account of their disability. The flurry of cases concerning medical aspirants with disability which has come before this court shows that the overarching issue is a sense of over medicalization of disabled bodies by the assessment boards. The approach often taken due to inertia or unwittingly is to assume that a person with disability may not be eligible for pursuing the course and then to put the candidates under tests to prove the assumption. The approach focuses more on the disability of a person than their ability. This turns the principle of reasonable accommodation on its head. The question instead that the board ought to ask itself is this: what measures can be taken to ensure that the candidate with disability can start their MBBS course on an equal footing with their prospective classmates. Stop.